Okay, everybody, we're going to take a deeper dive into the differences between direct and circumstantial evidence. First of all, we'll talk about direct evidence, and let's start with a definition. Personal knowledge or observation of the person testifying. This is somebody who's on the stand saying, I saw Joe kill Bill. You don't need an inference or a presumption to make the mental leap that Joe killed Bill. Somebody's sitting there saying that they saw it happen. If the testimony is believed by the jury, then the fact that relates to it is conclusively established. Direct evidence is always admissible as long as it's legally obtained, it's relevant, and it's not a privileged communication. Remember, we talked about attorney-client privilege and those kinds of conversations. Let's take a look at circumstantial evidence. This is evidence which indirectly proves a fact. It's based on inferences that the jury must draw. They must look at the testimony and say, well, if Bill went running into the store, he might have done it, rather than the personal knowledge or observations that are by the witness. Circumstantial evidence is admitted at the discretion of the judge. The judge has to decide whether it's relevant and has to think about other factors like how much time it'll take to introduce and will it confuse the jury? Might it unduly prejudice the jury when it's not appropriate? The weight of evidence. First of all, you need to understand that the judge is the trier of the law, and that is the judge decides what the jury can even hear. The judge decides on stipulations. The judge gives instruction to the jury on what they must consider and what they must ignore. And while the judge is the trier of the law, the jury, they are the trier of the facts. And they decide how much weight to give evidence. They decide what inferences to make from circumstantial evidence. They decide on the believability of witnesses and so on. So, how does a jury decide? We'll start with direct evidence. Most of that comes down to the credibility of the witness. Remember, you've got somebody saying they saw the defendant do something. Now, the jury has to decide, well, do I believe this person who's testifying? And the jury is allowed to use factors like the demeanor of the witness and the likelihood that what they're saying happened could have actually happened. Body language, and was the witness refusing to look at the prosecutor? Were they uncooperative or hostile to one side or the other? Did they tell the police a different story? That would show up in the transcripts from previous interviews. The jury can even consider whether the witness has been previously convicted of perjury or any crime that involves truthfulness. This would be brought up by the other side. Now, how do they decide on circumstantial evidence? Well, it's more difficult to evaluate, that's for sure. They do have to decide on the credibility of the witness, but also the jury gets to decide, so what does it mean? This person is saying they saw Joe run into the store. What does that mean to the case? And that's where the inference is drawn by the jury. That's the sole responsibility of the jury. They have to decide the weight to be given to each piece of evidence. And what does it mean? Like, the individual, the defendant, is known to have skills in safe cracking, and in this case, this crime, the safe was cracked. So they have to decide, okay, well, are there special skills or technical knowledge that this defendant has that would have been required to pull this off? Let's say the individual works at a company and gets fired and they still have a key and there was no sign of forced entry. Things like that can be inferred as additional evidence against the defendant. Oftentimes when a defendant is arrested, they're in possession of burglary tools, pry bars, screwdrivers. Did that defendant have the physical capacity to be able to break a window or physically lift a safe? Did they have the mental capacity? Things like that. All up to the jury. Let's talk about circumstantial evidence of intent. This is circumstantial evidence that's used to prove intent by the defendant. The most common ways to do this are to establish intent from modus operandi, motive, and threats. We'll talk about each. First of all, modus operandi, or MO. This literally translates to method of operation. A lot of times, a suspect, let's say a burglar, will have a particular way that they like to pull off their burglary. They might ring the doorbell, they might go around the back, use a pry bar. These are things that are unique to that individual. They're similarities. If those can be shown to connect the defendant to burglaries of the past, they are admissible as evidence of MO. The judge gets to decide whether or not evidence of MO is allowed to be considered by the jury. And the prosecution just has to show the court that there are enough similarities to show that it's a signature method. Motive. Why did the defendant commit this crime? Motive is important when showing the jury why a defendant might have been motivated to commit a crime. Motives are usually things like greed, hate, jealousy, revenge, love, you name it. As long as the link can be shown, it will be admissible. Threats. This comes up when the defendant made threats and you have witnesses that can testify to the fact that threats were made. I'm going to kill you. The jury has to consider whether they're common, vague threats. A lot of times people will say, I'm going to kill you, or if you do this, I'll kill you. They really don't mean it. How recent was that threat made? The credibility of the person who's testifying about the threat. Threats can also be used when somebody is claiming self-defense. They can say that they were threatened or they felt threatened. And if they can show evidence or witness testimony that there were threats made against them, that gives credibility to their self-defense case. Let's talk about some circumstantial evidence of the guilt of the defendant. Here's some examples. What the suspect does after the crime occurred might be used as circumstantial evidence of their guilt. Flight to avoid prosecution. Now, this might mean getting on an airplane and leaving the country, but it also might mean hiding in a drainage ditch while the helicopters are searching for the suspect. An innocent person wouldn't do that. So this and attempting to hide evidence, stashing, hiding, if that is brought forward in trial, it can be used as evidence of what's called consciousness of guilt, which means an innocent person wouldn't do these things. This must be a guilty mind that's trying to hide. Possession of stolen property, that happens a lot when the suspect is in possession of the items that were stolen. That is circumstantial evidence that they might have had something to do with the crime. It can be weighed by the jury. Sudden wealth. Okay, Joe doesn't have a job. He usually drives around on his little brother's Schwinn bicycle. But all of a sudden, I saw him driving a Mercedes-Benz S-Class, brand new car. That is unexplainable. It might be inferred by the jury that sudden unexplainable wealth could have something to do with the individual being involved. And attempts to silence or persuade a witness. Evidence is brought into court that the defendant took one of the witnesses aside and said, listen, you need to cover for me, or please don't testify, or even attempts all the way up to trying to kill a witness. That can be used to infer guilt. Let's talk about character witnesses. They are brought in to convince the jury that the defendant did something consistent or even inconsistent with their own character. If a character witness or the defendant has a reputation of telling the truth, the jury can make an inference, if they want to, that the witness is currently telling the truth because they're a truthful person. It's up to the jury how much weight they want to put on that, how much they want to believe that. Character witnesses can only testify to what they know of a person's reputation in the community. For example, character witnesses brought in on behalf of the defendant. They can't give their opinion. I think he's a great guy. He's wonderful. All that a character witness can talk about is what they've heard directly from the community. In other words, their reputation, what people say about the defendant. The defendant is a great guy. He does a lot of volunteer work, whatever it is that they are aware of in the community versus their own personal opinion. The prosecution can't bring in character witnesses to attack the defendant's character unless the defendant has already placed character at issue, which means they brought their own character witness in. Now the prosecutor can use character witnesses to counter the first character witness. There's three basic situations where character witnesses are used. Number one, by the defendant to try to use their own good character and good name to convince the jury that they simply didn't commit the crime. The jury can then decide whether to use those specific traits to infer that the defendant did or didn't, or at least to add weight to one side or the other. And finally, character traits of the victim might be used when those are relevant to the crime, and I'll tell you what I mean. First of all, the defendant. So the defendant is charged with murder and they claim self-defense. The defense calls a character witness who says that the defendant is known to be a gentle person who never becomes violent. So in that situation, the jury can decide whether or not those character witnesses are really being truthful and whether to believe it and how much weight to put on it. He seems like a kind of a pacifist. I don't see why he would be involved in this. And here's the example of when character witnesses are used regarding the victim. Say that's a homicide victim. The defendant is claiming self-defense. The defense brings in a character witness who testifies that this victim had a really bad reputation of being violent, mean, and getting angry. And they can build on that, and they can create doubt. And the jury might say, well, maybe this defendant was defending himself. This guy sounds like a kind of a mean guy. When there are character witnesses brought into court, the prosecution has two options. First, they can attack the credibility of character witnesses that were brought in on behalf of the defendant. They can show bias. Bias means, well, this is a family member. They have a relationship. They have a financial interest in the defendant not being convicted. So they're biased and they may not be telling the truth because of that. The prosecution can also show that the character witness brought in knows more about the defendant than they're revealing. They can try to prove that the character witness is also aware of bad behavior but didn't talk about it. The prosecutor can bring that up. Then the prosecution can bring in their own character witnesses to counter any assertions made by the defendant's character witness. Other crimes, wrongs, or other acts. This is what we like to call priors. So evidence of priors, prior convictions, let's say, those are not admissible to prove character unless they're in response to certain issues that were raised by the defense. These are up to the judge, but I can't bring in Billy's rap sheet and ask the jury to infer that because he's been convicted 10 times in the past for different things that he's just a criminal and therefore likely did this. I can't do that, but I can bring in priors when I need to establish things like proof of motive. There could have been a severe debt from a prior conviction. Opportunity, intent, preparation, plan, MO, we talked about modus operandi earlier. Knowledge or a claim of mistaken identity. What do I mean by that? Let's say a 75-year-old man is on trial for bank robbery, and he claims that the witness wrongly identified him as a suspect. The prosecution can show that robberies by seniors are very rare, and the suspect has a couple of prior arrests for robberies in the past 3 years. I think they made a movie about this recently. Prosecution can bring in those priors to overcome that claim. Habit or custom. The fact that a defendant had a habit or a custom of doing something can be used to infer that they did it when the crime was committed. It can also be used to show that they weren't involved in the criminal conduct. Here's an example. Kidnap victim, very tidy housekeeper. So when the police are called to the scene, the house appeared to have been ransacked, victim was gone. The prosecution may ask the jurors to infer that the victim was forced to leave the scene against their will. Another example, victim's an elderly man, very frugal. This might be in an embezzlement case. Prosecution has asked the jury to infer that a large check written on the victim's account for an extravagant gift was probably not written by the victim because that's out of character for that person. Prior false claims. So let's say somebody is being prosecuted for insurance fraud. The defendant has previously filed false insurance claims. That can be brought in. And now as a defense, the victim in a criminal case is shown to have filed previous false crime reports. In both of these cases, the jury will be asked to infer that the current claims are false also. Just to keep in mind, if through the course of this criminal trial, the defendant at some point tried to plea bargain with the DA, some juries might look at that and reason that he must be guilty. So those can't be used, the fact that he tried to plea bargain. Most states don't allow this. They don't allow testimony about attempts to plea bargain or the fact that the defendant previously entered a guilty plea but then later withdrew it. Those things are left out. Here's some more examples of circumstantial evidence involving the victim. Sometimes the victim's injuries can provide circumstantial evidence of a crime. This usually requires bringing in some expert testimony from doctors or professionals, most often to explain injuries, especially in a homicide. Here's another example. In a rape case, an expert can testify about bruises found during a rape examination. In a child abuse case, an expert can testify that the parent's explanation doesn't make sense, doesn't match the injuries. That's expert testimony. This is an important point. Rape shield laws. Back in the 1970s, the early part of the 70s, it was common for the defense attorney to attack the victim's sexual history in a rape case. This is the stuff horror stories come from. These kinds of cross-examinations were like turning the tables on the victim and making the victim out to be the suspect. You can only imagine how difficult it was for a victim to undergo this kind of attack by the defense. In sex offense cases, Federal Rule 412 restricts the relevance of the victim's past sexual behavior or their alleged sexual predisposition. The statute reads, "The following evidence is not admissible in a civil or criminal proceeding involving alleged sexual misconduct. Evidence offered to prove that any alleged victim engaged in other sexual behavior or evidence offered to prove a victim's sexual predisposition. Not allowed." There are a couple of exceptions. Number one, evidence of specific instances of a victim's sexual behavior if it's offered to prove that someone other than the defendant was the source of physical evidence like semen and injury, or evidence of specific instances of a victim's sexual behavior with respect to the person accused of the sexual misconduct if it's offered by the defendant to prove consent or if it's offered by the prosecutor. And finally, any evidence whose exclusion from the trial would violate the defendant's constitutional rights. The judge will make the call in these cases. Well, that concludes our look at Chapter 5.